Welcome to today's training session for internationally educated midwives arriving to work in the UK. Today's topic is going to cover consent and ethics. It's important to understand that it is a legal and ethical necessity to maternity care. So these are the learning objectives. By the end of this session, it is hoped you'll have a greater awareness of the principles of consent in relation to the care that you give as a midwife, looking at a definition, the importance and legal implications of gaining informed consent, and we'll also review the core principles of biomedical ethics and how they govern midwifery practice and research. So the Nursing and Midwifery Council, as hopefully you're aware by now, are the organisation which regulates nurses and midwives in the United Kingdom, as well as nursing associates in England. Now they set standards, hold a register, quality assure education, and investigate complaints. In their document, the Code for Nurses and Midwives Code of Conduct, as shown here, there is reference made to the importance of gaining properly informed consent and documenting this before carrying out any single action. As regulated professionals, this also requires us to have an understanding of a person's capacity to give consent and the laws that are surrounding this. Before we go any further then, let's first give a full definition to what the word consent means in the context of healthcare. NHS.UK define consent as that a person must give permission before they receive any type of medical treatment, test or examination. Now, to be valid, consent must be voluntary, meaning that the decision to either consent or not to consent to treatment has to be made by the person and must not be influenced by pressure from medical staff or even friends or family. Should also be informed. The person must be given all of the information about what the treatment involves, including the benefits and risks, whether there are reasonable alternative treatments, and what will happen if treatment does not go ahead. And the person also needs to be deemed to have the capacity to make the decision. The person has to be capable of giving consent, which means they need to understand the information given to them and can use that information to make an informed decision. If an adult has the capacity to make a voluntary and informed decision to consent to or refuse a particular treatment, their decision has to be respected. This is still the case even if refusing treatment would result in their death or the death of their unborn child. If a person does not have the capacity to make a decision about their treatment and they have not appointed a lasting power of attorney, the healthcare professionals treating them can go ahead and give treatments if they believe it's in the best interests. But clinicians must take reasonable steps to discuss the situation with the person's friends or relatives before making these decisions. So how is consent given? Firstly, it can be given verbally. For example, a woman saying out loud that they are very much happy to have their blood taken. It can also be given in writing, so signing a consent form to surgery. Sometimes non-verbal consent is also given, for example, nodding or giving an arm stretched outwards in preparation to have blood taken. But if there is ambiguity about consent, it's best to gain verbal or written consent as well. Consent should be given directly to the person responsible for the procedure or treatment, and it is the duty of the professional performing an action to check that the person in front of them understands what is about to happen and that they are happy for them to do said action. Additionally, a person can withdraw their consent at any time, and this is even midway through a procedure. This must be respected. There's a legal case from 2015 called Montgomery versus Lanarkshire. This drew fresh attention to informed consent. So the lady in the case, Nadine Montgomery, was a woman with diabetes and she was of small stature. She delivered her son vaginally. However, he experienced complications owing to a shoulder dystocia during birth, and it resulted in his hypoxic insult, which consequently caused cerebral palsy. Her obstetrician had not disclosed the increased risk of this complication in her vaginal delivery, despite Montgomery asking if the baby's size was going to be a potential problem. Montgomery sued for negligence, arguing that if she had known of this increased risk, she would have requested a caesarean section. The Supreme Court of the UK announced judgment in her favour in March of 2015. The ruling overturned a previous decision by the House of Lords, which had been law since at least the mid-1980s, and it established that rather than being a matter for clinical judgment to be assessed by a medical professional opinion, a patient should be told whatever they want to know, not what the doctor thinks they should be told. So this really put a spotlight on the importance of informed consent. Now, this is a very, very basic example of midwifery care, quite a silly example really, of consent being sought and gained. So it might seem very obvious action and sequence, but let's just quickly run through this. So let's say we're at a booking appointment and the midwife asks the person in front of them, "Are you happy if I measure your height and weight? We do this at booking to calculate your body mass index." And the person might reply, "Yes, of course, but can I ask what you need to know my BMI for?" And the midwife might reply, "This is because we want to support you in achieving and maintaining a healthy weight throughout your pregnancy and beyond, and having a BMI that is outside of a healthy range means that your pregnancy risks may increase." And with all that information, the pregnant person is now saying, "Okay, that's definitely fine with me." So the midwife has gained informed verbal consent, and she can document this in her notes before proceeding to take the person's height and weight measurements. So let's look at examples of when consent is not needed. So the first example is if the person needs emergency treatment to save their life, but they're incapacitated. For example, they're unconscious. So the reasons why treatment was necessary should be fully explained once they've recovered. Second example, the person immediately needs additional emergency procedure during an operation. There has to be a really clear medical reason why it would be unsafe to wait to obtain consent for this matter. Thirdly, severe mental health conditions such as schizophrenia, bipolar disorder, or dementia. If the person lacks capacity to consent to the treatment of their mental health under the Mental Health Act, in these cases, treatment for unrelated physical conditions still require consent, which the patient may be able to provide despite their mental health condition. The Mental Health Act of 1983 is the main piece of legislation that covers the assessment, treatment, and rights of people with a mental health disorder. Another example would be, though, if a person was requiring hospital treatment for a severe mental health condition. They've self-harmed or attempted suicide while competent and are refusing treatment. Under the Mental Health Act, this can be a reason where consent is not needed. However, the person's nearest relative or an approved social worker must make an application for the person to be forcibly kept in hospital, and 2 doctors must assess the person's condition. The last exception may be for a severely ill person who is living in unhygienic conditions under the National Assistance Act of 1948. So a person who is severely ill or infirm may be living in unsanitary conditions. They can be taken to a place of care without consent. In just wanting to get you to think about some implications on caregiving when consent is refused, these are just a few ideas that came to mind of situations where the person's decision changes the care plan significantly. And we always want to make sure that our patients feel that they are informed and can make their own decisions about their care. There are plenty of other examples, but let's say a woman is offered during her initial appointment an explanation for why and which bloods the care provider would like to take. Now, a portion of these are to screen for infectious diseases, namely HIV, Hep B, and syphilis. Now, if with informed knowledge she doesn't want her bloods taken, the care provider won't know if she's positive for one or more of these infectious diseases. So it would be recommended to offer these again later, at a later date. However, we need to be careful not to use coercive language. It does have implications, though, for us as healthcare providers in not knowing if that person has an infectious disease, and that will implicate her care as a sense of needing to use personal protective equipment, and possibly implicates their unborn baby during the birth process too. So another example I thought of that crops up in practice, it's quite standard practice to offer a vaginal examination every 4 hours once in established labour. But some women don't want their cervix to be assessed, and we need to support our ladies in this whilst not having as much information as we would want as midwives about where they're up to in their stage of labour. If the woman has informed consent, we need to listen to her and go with her choices. And a final example I thought of was if someone had been informed of the reasons and methods an induction of labour was being offered. And quite a lot of women may choose to decline an induction of labour when it's offered, initially anyway. Sometimes it's necessary to plan an elective caesarean as an alternative route of expediting the baby if there are other risks involved in the pregnancy continuing, but this will always be a consultant care plan. But these are just a few common examples of refused consent with lots of implications within your maternity care. Now, we need to be sure to gain consent and not through coercion. Coercion is the use of force to persuade someone to do something that they're actually unwilling to do. In certain situations, a little legal knowledge can actually be unhelpful. And to give you an example of this, in a pending case of a paediatric doctor, he went to court over the fact that he stated to new parents that now that the baby had been born, the baby had its own rights, and so the doctor could cut the cord and give whatever treatment was needed. However, the parents at the time had not given consent to any particular treatment. This is an example of understanding the limited idea that a baby does acquire rights at birth, but with the parents there to protect and consent for him, there would have to be some life-saving emergency and a court order to override the parental responsibility. Therefore, the midwife would have a duty to act under the NMC code to advocate, respect the wishes of the parents, and to escalate concerns of coercion. I've put this little bodily autonomy quote in here, and it kind of sums up what we're talking about with making decisions for your own body. My body is for me, my body is my own. It's about power and it's about agency. It's about choice and it's about dignity. This was defined by the Sexual and Reproductive Health Agency in regards to giving sexual consent. However, I think it applies also to healthcare. Women need to know exactly what is being offered, have all the right information to make the right choices for them in all the way throughout their care. And my last little point on this slide is that once consent is obtained, it absolutely needs to be documented. So we can't forget to document that we've had these conversations. Okay, ethics and legal action. So ethics are moral principles which affect moral decision making. Now this involves determining what is right, good and fair. Legal issues, on the other hand, are decided by law. Law can be defined as a rule of conduct or action put in place to ensure public safety and control undesirable behaviour. Ethical dilemma, then, refers to when there is difficulty deciding which actions take priority over another. It can also describe a situation in which the patient's rights and the professional's obligations are in conflict. Some midwifery examples of ethical dilemmas include, but are not at all limited to, genetic engineering or choice of sex within the IVF process and surrogacy. Also, borderline viability of a baby and whether we should resuscitate the baby or not at birth. as well as withdrawal of life support, and there are lots of others that crop up within maternity care. The NMC code requires nurses, midwives and nursing associates to make sure that they do not express their personal beliefs, including political, religious or moral beliefs, to people in an inappropriate way. There is currently a statutory right of conscientious objection for nurses, midwives and nursing associates in 2 areas of care. Firstly, under Section 4 of the Abortion Act 1967, this provision allows nurses and midwives in the UK to refuse to participate in the process of treatment which results in the termination of a pregnancy because they have a conscientious objection. There's an exception where it is necessary to save the life or prevent grave permanent injury to the physical or mental health of the pregnant woman. Secondly, under Section 38 of the Human and Fertilisation Embryology Act of 1990, there is a provision that allows nurses and midwives the right to refuse to participate in technological procedures which achieve conception and pregnancy because they have a conscientious objection. The code states that nurses, midwives, and nursing associates who have conscientious objections tell their colleagues, your manager, and the person receiving care that you do have a conscientious objection to a particular procedure. You then need to arrange for a suitably qualified colleague to take over the responsibility of that person's care. We've also got ethical duties within the role of the midwife to escalate concern around safeguarding and legally mandated reporting of female genital mutilation. It is a criminal offence to take a young girl abroad to have FGM or to perform FGM within the UK, and it's a health professional's duty by law to report to the police as soon as they have any concerns of any FGM. So I've mentioned the only 2 conscientious objection reasons, which are termination or conception technology. So any other issues that arise within the realm of ethical, religious, political or moral personal belief, professionally these need to be set aside in order to be able to look after people holistically. And so sometimes we need to be mindful of the fact that we may not agree with what's happening, but be able to still provide safe care for a person. Okay, I'm going to talk now briefly about 4 general principles of ethics in healthcare, biomedical ethics for a shorter term. You may not have heard of these, you may have heard of them before. We've got beneficence, non-maleficence, I can't even say that word, autonomy and justice. Now, these are at the heart of midwifery practice as well as any research that takes place. Just to go through these briefly. Beneficence, this means to act in a person's best interests. Essentially, it means doing good for the people in our care, not only because it requires that we treat persons autonomously and refrain from harming them, but also that we contribute to their welfare. Non-maleficence, this is the principle of doing no harm to patients. This may be intentional or unintentional, however, both can apply to the laws of negligence. Autonomy. This is a vastly complex concept which has implications on a great number of disciplines, from politics to moral philosophy. For a long time in the healthcare profession, the doctor-patient relationship was one grounded in the patient deferring to their doctor for all the right answers when it came to their health. However, there has been a huge shift from this model to one in which the patient has a more active role in determining their healthcare needs and in choosing what treatment options would be best suited to them. So as such, the relationship between the health professional and the patient has become more of a partnership, with both taking an active role in making joint decisions. And this compares to the older model, which was more akin to the relationship between a parent and their child. And fourth, we've got justice. In the case of a healthcare, we consider distributive justice, which is defined as the fair, equitable and appropriate distribution of benefits and norms. Often healthcare resources can be limited, so it's the job of public health and healthcare professionals to consider how best to distribute them. This can be a difficult task, and even in the UK we can see inequalities in healthcare based on geographic locations and socio-economic factors. When applied to research with human participants in health and social care settings, these basic principles are translated into many tenets, including but not limited to informed consent, mutual respect, confidentiality, anonymity, trust, truthfulness, sensitivity, protection of vulnerable people, debriefing, and the safety of researchers. Ethical dilemmas can arise for midwife researchers when their code of practice conflicts with the principles of research ethics. Clinical midwives and researchers alike, however, should ensure that each tenet is thoroughly considered and applied to their work. So we've got protection of the vulnerable, that is covering do not harm and treat fairly. Informed consent covers autonomy and acting in the best interests of a person. Mutual respect covers beneficence, doing good, and autonomy. Truthfulness and transparency, these cover justice, autonomy, do not harm. You get the idea. All four of the key principles I've had on the previous slide all overlap, and they cover such a vast range of separate issues and potential boundaries. Care should remain person-centred, and this is a really big one in midwifery in the UK, in working with women and their families throughout the whole journey, making personalised care plans with their involvement and their decision-making all the way through. We've also got debriefs, sensitivity and anonymity, openness. These are all daily considerations in your working life as a midwife. Confidentiality is an easy example of a possible line of an ethical dilemma. When someone asks for something to be kept in confidence but reveals that someone is at risk of harm, we sometimes have to not promise that confidence and act in the person's best interest and without their consent. Just as a brief example, a woman discloses domestic abuse and she's pregnant with 2 children at home. So you can see that ethics is not always easy, and there's not always an easy answer or action, but to uphold the 4 general principles requires an awareness of all these things that are held in tension with each other. Okay, we've come to the end of this presentation. Here are all the references used for today's slides. Do take a look at those. And as always, I'd love it if you have the time to complete this feedback form and provide any comments or feedback on this slideshow. We look forward to seeing you next time. Thank you.